Hey guys, welcome back to our series on the federal rules of evidence. We are going to be jumping into Rule 412B, which is the exceptions. So just to recap the last video, 412A says that you're not going to be allowed to bring in any evidence to show that the victim engaged in any other sexual behavior or to prove their sexual disposition. Rule 412B is going to give you a couple exceptions that's going to allow you to bring in the following evidence. So first, in 412B1, you're going to be talking about criminal cases, and B2 is going to be talking about civil cases. In criminal cases, the court is going to be allowed to admit the following evidence in a criminal case: evidence of specific instances of a victim's sexual behavior if it's offered to prove that someone other than the defendant was the source of semen injury or other physical evidence. What does this mean? This means essentially that if you're the defendant, you're going to be allowed to bring in evidence of specific instances of the victims having sex with other people if you're bringing it in to prove that I'm not the source of the semen or injury. That's the first exception. The second exception is going to be evidence of specific instances of the victim's sexual behavior with respect to the person accused of the sexual misconduct if offered to prove the defendant to prove consent, or if offered by the prosecutor. What does this mean? That you're going to be allowed to bring in evidence of specific instances of having sex with the same person earlier if you're bringing it in to prove that there was consent. This gets a little tricky because how do we define what sexual behavior is? So the courts have a lot of discussion about this. And the question is should different statements, fantasies, should emails be allowed in? So it depends. And I encourage all of you guys to look further into that. And then third, evidence whose exclusion would violate the defendant's constitutional rights. What does this mean? If the defendant is trying to make a certain narrative argument about the victim and it goes to the constitutionality of their defense, it would be allowed. This is like a last shot, though, and it's a little more wish-washy than the others. Okay, then we're going to break down now civil cases. So what does this mean? In a court, they are allowed to admit evidence to prove a victim's sexual behavior if the probative value substantially outweighs the danger of harm to the victim and of unfair prejudice to any party. This is a reverse 403 analysis. Normally, in a 403 analysis, the probative value needs to be low and the risk is high, and it still could be allowed in if it has some criteria of probative value. However, in a 412B2 analysis, the probative value needs to be high and it needs to substantially outweigh any danger of risk of unfair prejudice. So the probative value needs to be very high as opposed to 403 needs to be low. The court is going to be allowed to admit this evidence only if the victim has placed it into controversy where they disagree. And this goes to allowing the defendant to have an adequate defense. I hope that clears it up. If you have any questions, make sure to leave them in the comments, and I hope you guys have a great day.